I don't even want you pleading to this. I really don't. There's no justice there. Nobody says you can't keep your child home if he's thrown up because he's got a heart condition. The law, as they say, is not an ass. So if you want, if that's really what happened, call in the prosecutor. Did you tell the prosecutor this?
Stand on justice.
What's she gonna do? Plead no contest?
Yes, Your Honor.
Does she have any other cases that have been taken under section 771.1?
No, Your Honor. She's got a
She ever had any criminal history at all?
Your Honor.
Is that true, ma'am?
Sure.
If you plead no contest to the assault and battery charge, this is punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that? A no contest plea, can you mark that? A no contest plea has the same effect as a guilty plea. Do you understand it? I'm told the reason for a no contest plea here is because there's a possibility of civil litigation. So I'm going to go ahead and go along with it. You understand that?
Sir.
Mr. Crawford, for purposes of arraignment, she stands mute, waives formal reading.
Correct, Your Honor.
And if you plead guilty, ma'am, I want you to understand, or no contest rather, the conviction will enter now. I'll use the police report to establish a factual basis. I'll send you for a report. You'll come back, probation will make a report and recommendation, and then I'll sentence you at a later time. Do you understand?
Yes.
You sure?
Or not.
Well, I don't want you to say yes if you don't understand. I'll take your no contest plea to assault and battery. Do you understand that so far?
I understand.
Okay. And then I'll have you back for sentencing later at another time. And in the meantime, today you're going to go over to probation after I take your plea. And you're going to be interviewed by probation. You understand? They will then make a report and recommendation. But so far, I'm willing to go along with the 12 months probation under section 771.1. You understand that?
No.
All right. Do you understand all your rights? Did you read and understand the rights?
Yes, I do.
If you plead no contest, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
Okay. Counsel, do you stipulate I can use the police report to establish a factual basis?
So stipulated.
She's never been printed, I don't believe, on this one. You never went over and got printed on this, did you, ma'am?
No.
All right. To the charge of assault and battery, how do you wish to plead? No contest?
Yes.
You can't just answer by nodding your head. Okay?
Yes.
So I'm going to ask you, how do you plead to the charge of assault and battery?
Are you pleading no contest, ma'am?
No, I'm not. Yes.
You sure?
Yes.
Okay. I'll now review the report. All right, I'm satisfied.
Thank you.
There's a factual basis for the plea. Ma'am, are you on probation or parole?
No.
Has anybody forced you to plead no contest?
No.
I'm going to accept your plea of no contest. I'm going to take it under the provisions of section 771.1. I'm going to order a pre-sentence report. I'm going to give you a sentence date. You'll come back on the sentence date, and the sentence date will be on the 19th, Heather?
April 29th, Judge.
Yeah, what am I thinking? April 29th at 8:30. Do I need another one for court to school?
We do only have, I believe we only have the two. Let me look at the calendar right now. It's the
Man, would you
30th.
be willing to do something for me? I'm not gonna make an example of you. I would never do that. I had the court to school program at Trenton on April the 30th, right?
That's
Crawford,
correct.
would you be available to handle that case, Mr. Crawford, on that day? And I'm not gonna lie to you, it's gonna be a little bit more embarrassing for you. You're not gonna only have 20 or 30 people here, whatever we have. I'll give you credit on that day for any, and I'm not gonna send you to jail for court work or community service, just for appearing in court that day at the Trenton High School. Will you do that for me?
Yes.
And I'll let you in on a little secret. The truth is, I'm probably a little bit easier when people acquiesce to that, okay? So I'll set this for a sentence date on April the 30th at 8:30. It's court to, what time do I have to be there again?
We started at 9 o'clock that day.
So I really would appreciate if you would get there at 8:30, okay? Then you'll have a chance to review the report with your lawyer, Mr. Crawford. You'll make a note and get there so we can start right at 9, right?
Yes, Your Honor. Trenton High School.
Trenton High School, court to school. And you'll go over for a pre-sentence report. First, you're gonna go down the hall and get your notice. Now, I do have to order some bond conditions here, though. You do have to go over there and get printed today, okay? So you have to go over to the Woodhaven Police Department. Fingerprints have to be taken by 1 p.m. today, April the 15th. You cannot have any contact at all with the victim. No contact with the victim. You cannot write, phone, see, text, email, or communicate with the victim, or have anybody else do any of those things for you or on your behalf. Like I said, you have to go over and get fingerprinted at the Woodhaven Police Department by 1 p.m. today, fingerprinted and photographed. You cannot possess any firearms, no firearms. You're not to possess any dangerous weapons, okay? No firearms, no dangerous weapons. Also, being as though this happened at 19900 West Road in Woodhaven, you're not to go back there. Do you understand that?
Yes, sir.
You're not to go back to 19900 West Road in the city of Woodhaven. Do you understand all the bond terms and conditions, ma'am?
Yes, sir.
All right, you are all set. Go down the hall. We'll give you a copy of the bond sheet. We'll give you a notice date for Trenton High. Please make sure you're on time. Will you do that for me?
Yes, yes, sir.
And I'll wish you well then, okay?
Okay, thank you.
Good luck. Okay, Mathiasek, I can't remember the last name, how I pronounce it. 225R724-360. Good morning, counsel. Your appearance?
Good morning, everyone. William Balsky appearing on behalf of Corey Matazik, who stands right.
Matiazik?
Oh, Matazik, I believe.
Matazik.
Matazik, I'm sorry. As a fellow Polish person, it's
It sounds like my grandpa, yeah.
so.
I said it like your grandma?
He does, but I think.
Matazik.
Matiazik. All right. Your name?
Elizabeth Westbury, Your Honor.
All right, so you're here for a review. How's she doing?
Courtney is doing great on the program. I know this morning at status review, we briefly touched on that she had missed her probation visit with me last week. But she was within 10 or 15 minutes late. I wasn't able to meet with her due to other visits. But she did all the right things. She communicated with me. In the meantime, she completed her court work program for community service. Her VIP's been complete since February. But at this point, her probation is really revolving around treatment, her continued 12 steps and testing. She is slated to move to phase 2 next status review on April 29th, Your Honor. And I don't know much else I can add to that. She's back to work. She took the beginning of her program off from work so that she could accomplish those items. So I do have her in full compliance, Your Honor.
Just for the record, so I ordered a year jail term with credit for 1 day and said she was to serve 60 days beginning today, that I could consider not requiring her to serve it after a review hearing. What do you want to say, Mr. Volsky?
Well, first and foremost, Your Honor, most importantly, my client is 7 months sober. I know that she was given a gift here. She's taken full advantage of it. She's remained sober. She enjoys the program. She's done everything this court has required her to do. I know that, as Ms. Wild had stated, she finished community service, 40 hours. She did a 6-day work program. She signed up for the Arms Weekend. That's the first week of May. She is on a payment plan. She's made, I think she paid about a third of what's been owed. Obviously, as Ms. Wild stated, she took some time off to focus on herself and get, her sobriety under control, and she had some pretty serious health issues which required surgery, so she's progressing well in that area as well. She's 34 years old. She resides in Farmington. She's here with her mother today. Most importantly, Your Honor, no violation. She is terrified of doing that jail time, and she's terrified of relapse. So this is a great program that she enjoys, and I'll just ask you to forego giving her that jail time and just allow her to continue this program.
All right, anything you want to say?
No, thank you.
All right, so listen, I mean, all statistics tell me that somebody's doing this well, it's counterproductive to put somebody in jail, and that was the concern. But I want to caution you. So I'm not going to require you to serve those 60 days now. I'm going to suspend them till the end. But I'm going to caution you, don't let your guard down. You're looking at a whole year here, and I will give you the whole year if you don't comply. You understand? You have to get through the program. You have to stay straight. You have to keep doing this. You're just on the beginning of this. So stay with it. Okay? All right. That's what I'll do. Thank you very much. Have a good day. Keep doing what you're doing. Thank you.
Always good to see you.
You too,
Thank
Mr. Bull.
Can I approach me 10 seconds?
Sure. Come on around. May Johnson, 2678-40548. Your name? You have the right to a lawyer. This is parental responsibility charge. Would you like a lawyer?
No.
I'll go ahead and arraign you and send you to the prosecutor. On March the 31 of 26, the police think that you did not have your child at 24825 Hall Road in the city of Woodhaven, that you didn't require your child to go to school. But violation of parental responsibility, March 31, 26, 10 o'clock in the morning, a misdemeanor punishable by up to 500 fines, 90 days jail costs, or all of those penalties. Do you understand that? Did you sign, read, and understand an advice of rights form? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that? Okay. I'm going to enter a not guilty plea, $500 personal bond. I'll send you to the prosecutor. You talk to the prosecutor. Either way, you're coming back in front of me, okay? You are all set. How you doing, ma'am? Your name? So they're going to dismiss the original charge of parental responsibility. You are going to plead responsible to public nuisance, true? To that charge, responsible or not responsible? You plead responsible, that's a civil infraction. It's not a misdemeanor. To the charge of public nuisance, how do you plead? Responsible? I'll accept the plea. You're going to get that child to school, right? Yeah, you got to get him.
Yeah, he has an art condition that we didn't know about.
Well, I mean, look, if he's not getting to school because you're taking him to doctor's appointments, that's one thing.
He was home throwing up because he was a state wrestler. So after practices, he'd get really sick. We didn't know why.
Well, wait a second. Wait a minute. Slow down. I don't want you to get all upset. If the child is not going to school because the child is throwing up, to wit, sick, there's no basis for anybody to be charging you with parental responsibility violations. I mean, I don't even want to see you plead to a civil infraction if that's what's happened. Now, listen to me very carefully. You're crying, you're upset. I don't want you to be. I happen to think it's so important for kids to go to school, though, right? We all know that because they can't get through school if they don't go, and we need them to get through high school and go somewhere else if they can or want or what have you, trade school, whatnot. But if you only didn't take your kid to school because he was throwing up, and that was the overwhelming majority of the times, I don't even want you pleading to this. I really don't. There's no justice there. Nobody says you can't keep your child home if he's throwing up because he's got a heart condition. The law, as they say, is not an ass. So if you want, if that's really what happened, call in the prosecutor. Did you tell the prosecutor this? Are you lying to me?
Medical records.
Did you show him the medical records?
The school.
All right, just bear with me.
Yes.
Just bear with me. How many days did your child miss? Well, give me a roundabout number.
40. I don't, 15 is I think when I called, so,
And it's 20 since the beginning of the school year in August, late August, or,
yeah.
yes? And you think those are attributable to his medical condition?
He was in sports, and so after practice, he'd get sick, and then the next day he'd be sick. And I just thought he was catching virus with two people, since around a bunch of kids.
Your name?
William here, I have city Woodhaven, Your Honor.
Is this our last case?
Other than bench warrants or show causes, it is from.
So listen, did you look at her medical records of her son? She's telling me that the only reason, and I'm not saying she's right, but I tend to believe her, is the only reason her kid wasn't going to school is he has a heart condition. He'd go to practice for wrestling. He'd work work out, whatever. And then the next day he'd feel sick and she thought it was attributable to viruses and he was throwing up.
And it turned out to be cardiomyopathy.
So is that but do you have evidence that that isn't true, or that doesn't make up the overwhelming bulk of the absences?
I don't have any countervailing evidence, Your Honor, but that was part and parcel of why the people chose to decriminalize the.
I know, but you've decriminalized them from everybody, frankly, right? I'm just saying.
Not always, but yes.
Well, yeah, but I mean, I had about 7 of these today, I'm guessing. I could be wrong. And all of them were reduced to public nuisance. All I'm saying to you is if that's the basis for this lady, I don't want her to plead the public nuisance if she's not guilty of anything, whether that's a civil infraction or not. So I'm going to ask you to go take a couple minutes, look at the medical records, assuming you're ready to provide them to them, and you see if it verifies that. And if it doesn't, fine, then I'll take the plea. If it does, then I'm going to ask you to consider dismissing. Fair?
Well, do you have that with you?
It's on my phone, it's just like the my chart.
Your Honor, could we just take a moment here? I don't even know why we need to excuse ourselves.
Go ahead.
If that's okay.
Go ahead. I'll tell you what, I'm going to ask everybody to refrain from saying anything to me. I'm just going to go off the record and sit here and you guys take your time.
The hearing begins with a woman appearing in court to enter a no-contest plea to a misdemeanor assault and battery charge. The judge carefully explains her constitutional rights, the consequences of the plea, and the possible penalties, ensuring she fully understands that a no-contest plea carries the same legal effect as a guilty plea. After confirming the plea is voluntary and supported by the police report, the judge accepts it, orders a pre-sentence investigation, and indicates that he is inclined to follow a probationary sentence under Michigan's delayed sentencing provisions. As part of her bond conditions, she is ordered to have no contact with the victim, report for fingerprinting, avoid firearms and dangerous weapons, and stay away from the location where the incident occurred. Before concluding the case, the judge asks the defendant to participate in a court-to-school program at a local high school. He openly tells her that appearing before students will be more embarrassing than ordinary court, but explains that it can serve as a valuable learning experience, while also helping her avoid additional jail-related obligations. The defendant agrees to participate, and the judge schedules her sentencing accordingly. The hearing then shifts to another defendant enrolled in a sobriety court program. After reviewing her outstanding progress, including 7 months of sobriety, completion of community service, treatment compliance, and positive probation reports, the judge decides to suspend a previously imposed 60-day jail sentence. He praises her efforts, but warns that any future violations could result in the full sentence being enforced. The Feudert, most emotional moment comes during the final case, involving a mother accused of violating parental responsibility laws because her child repeatedly missed school. As the woman explains through tears that her son's absences were caused by an undiagnosed heart condition that left him vomiting after wrestling practice, the judge immediately questions whether justice is being served, refusing to accept even a reduced civil plea without reviewing the medical evidence. He orders the prosecutor to examine the child's medical records and consider dismissing the case entirely if the mother's explanation is verified, demonstrating that fairness should always take precedence over securing a conviction.